What happens in high-stakes business arbitration hearings? Imagine a room where big business disputes are settled not in a courtroom but in a private setting with experts called arbitrators. These hearings are serious but follow a different flow than regular court trials. They happen when companies want a faster, more confidential way to resolve disagreements over contracts, money, or business practices. The process starts with choosing the arbitrators. Usually, the parties pick experts in business, law, or the specific industry involved. If they can't agree, an arbitration organization or court will appoint them. The tribunal might be one person or three, depending on what the contract says. These arbitrators must be fair and independent, making sure no one has an unfair advantage. Before the hearing begins, there is often a preliminary meeting. This helps set the rules, decide how long everything will take, and clarify what issues will be discussed. Unlike court cases, there is usually less exchanging of documents, which makes the process quicker. Still, parties can share relevant evidence like contracts, emails, or reports. When the hearing starts, each side presents their case. They give opening statements to outline what they believe happened. Then, they call witnesses and experts to testify. These witnesses answer questions from both sides, and the arbitrators oversee this to keep things fair. Evidence can include documents, photos, or expert reports. The parties also make legal arguments about how the law applies to their case. The hearing itself is less formal than a court trial but follows a clear structure. The arbitrators manage the process, making sure everyone has a chance to speak and that the proceedings stay on track. The goal is to gather enough information to make a decision. After all the evidence is presented, the arbitrators go into private discussion. They review everything, consider the facts and legal points, and then decide what the outcome should be. They write a formal document called an award, which explains their findings and what remedies are granted. These remedies could be paying damages, stopping certain actions, or fulfilling contractual obligations. Once issued, the arbitration award is final and binding. It can be enforced in courts if needed, and there are very few ways to challenge it. High-stakes arbitration cases often involve detailed legal strategies, expert testimony, and a lot of preparation. The process is designed to be faster and more private than traditional court cases, which is a big advantage for businesses wanting to protect sensitive information and resolve disputes quickly. In the end, arbitration offers a private, efficient way to settle serious business disagreements, giving companies a clear path to resolution without the delays and publicity of a court trial.